Harper government would decide to single out refugees, and most particularly those desperate enough to hire a human trafficker, is because they are the weakest of the weak. And is that not the mark of a bully? You go after somebody that nobody else is going to care about standing up for, because that is the mark of the bully. It's a lot easier to single somebody out and divide and conquer, and that's what the Harper government has been doing throughout the 6 years of its reign at the helm of this country. It has marginalized people. It has identified the Charter as a flawed document, and has said it's nothing but a document that's used by special interest groups. Special interest groups which, to reiterate, include Aboriginals, women, the disabled. That's a pretty big group of people. That's the rest of us who did not vote for a government that would subject the Charter of Rights and Freedoms to such degrading and reprehensible treatment.
Thank you. So what I'm going to do is I'm going to turn it around to questions from the audience. So if you want to ask a question, just we'll do it classroom style since we're in a classroom. Anybody? Michelle?
I don't want to dominate, so if anybody has any questions, please jump on in. Everything I've ever seen this government come in with, the Harper government, seems to go against all of our laws, no matter what it is. Stéphane Dion came to Calgary and talked about Senate reform, and it just sounded like his Senate reform argument basically said that this bill, C6 or C7 of Senate reform that Harper wants to bring in is going to clog up our system. Well, me as a Canadian, I'm wondering, is there a certain point where we can stop this government? Because every single bill that they're bringing in is going to clog up the system. We have this new criminal system coming in that they want to throw all these unreported crimes in jail for. We have new bills, all sorts of interesting ideas. We were talking about detaining. Well, at a certain point, we're going to break the court system with all of the new concepts that they want to bring in. How do we go about stopping this government from clogging up our legal system at every single step of the way? If everything is unconstitutional, if it, I guess, where do we even start by stopping this government from clogging up our legal system?
Wow, I think that's the question of the night. It's a difficult question to answer because I'll start off by saying that we do have, as citizens, the right to bring an action against government where we think that the government has acted unconstitutionally or is bringing in an act or legislation that is contrary to the Charter. It is not an easy process. It's a cumbersome process, and I see Linda nodding her head. I'd like to turn things over to her shortly because she indeed has some personal experience with taking the government to court, or a government agency to court, and winning after about 11, 12-year battle. So we have that right, but we do have to provide notice to the Crown and to essentially sue the government for alleging an unconstitutional act. Sure, we have that right, but as Linda will vouch, it is extremely expensive. I don't think I'm being off base here and suggesting that legal fees could easily run you to $100,000 or more. So we have that right, but do we have that access, in fact? Now, there used to be, in this country, a program called the Court Challenges Program, which did provide limited funding to a limited number of constitutional challenges that were launched by ordinary citizens. But unless I'm terribly mistaken, that was one of the first items on the chopping block when Stephen Harper first became Prime Minister of this country in 2006. And Linda, I hope you don't mind if I threw in your allusion to your personal experience with this matter, if you feel comfortable in jumping in. I think people would be interested in hearing about your experience with it.
Sure, I will. Before I do that, though, it's an interesting, we have a division of powers in this country, right? And it's one of the ways that we keep each other in check, if you like. So we've got the courts that are, their job is to interpret the laws, and we've got Parliament whose job is to pass the laws, and citizens put Parliament in there, and we were supposed to be holding them to account. The problem we have is that the only way that you can challenge a law that's being proposed that you see as unconstitutional is what Ryan mentioned, through the court system, and it is a cumbersome process. Now, of course, we could obviously start mentioning or pointing out publicly that these laws are probably unconstitutional. For example, last week, not even last week, a couple of days ago, no, last week, the Supreme Court of Canada pointed out that a law regarding getting a search warrant, or not wiretapping somebody without getting a search warrant is unconstitutional, and you need to amend the law. Well, the government is currently proposing to do something similar with regard to keystrokes on and requiring computer service providers to keep track of all this. And again, if a person is interested, they don't have to get a warrant or anything. They can assign somebody who can get that. So you would think the government would look at this case that just came down that said that's unconstitutional, even though it's in the criminal code, right? It's there, but it's not appropriate. Then obviously this is not going to be constitutional. So it's awkward. It's difficult. You know, it's one of the ways that we need to really think about engaging our citizens in understanding this stuff and acting and saying to their MP, what the heck are what are you thinking about with all this stuff? Because it's all going to be struck down. It's going to tie up our court system, not to mention the cost of defending all this. So getting into my case, I took on Air Canada on the basis that they discriminate against obese people by requiring them to pay double for seating. And they fought me, Air Canada fought me tooth and nail. They used every kind of possible court action, delay, and I said to them at one point finally, I said, you know, you've taken on a lawyer, so I know what all these tactics are, and I'm not going away. And they cost the taxpayers money, because Air Canada has been bailed out a few times by us, and so on, but they accused me of wasting the taxpayers' money. And I was very insulted by that, because I thought I had a really legitimate issue. And it was a very weird process. I had originally, the investigation at the tribunal, it was the transportation agency, had found in my favor, and then Air Canada had objected. They didn't like the investigation, and all of a sudden it went missing, or it was set back for 3 or 4 years before they finally held hearings and that. And I finally got some funding from the Court Challenges program to make a Section 15 argument. And eventually I won, in addition to several other disabled people who have to pay for extra seating. For example, if they require you to have an attendant because they don't want to have to take you to the toilet while you're flying, they used to require you to pay full fare for that attendant that they were requiring, things like that. So they lumped me in with a lot of different kinds of disabilities, and we got a ruling that said one person, one fare, and even if you require some accommodation, and that it wasn't going to cost them too much money to accommodate people. However, having said that, most people, they give up because it takes so long to get a remedy. There's one lady in Alberta who spent 23 years right now fighting for equal pay for male and female work. You know, she's ready to retire from her dang career, and she still hasn't got a resolution. So, you know, it's one of the flaws, but on the other hand, this is the system we've developed. We've got this, and it's supposed to keep each other in check. And that's why what we really need to do is encourage this government to be more aware of the Constitution and to actually be more thoughtful on the constitutional implications. A cynic might say they don't care and they know about the constitutional implications, but they want to be seen to be dealing with all these things. That's what a cynical person would say, and that's what I used to say about the government of Alberta. They'd start passing things like saying marriage has to be between a man and a woman. Well, that's not their jurisdiction to even pass that law. That's federal. But they did it, and they knew probably that they didn't have jurisdiction, but it was popular, or was perceived to be popular to do that. And I think that's what's happening with some of this stuff that's happening federally. I'm no expert on political science at all, but I know that I teach about this division of powers in my law class, and it is considered to be, it's supposed to be even Steven, you know, not any one thing having too much power, and that's what protects us as citizens. And I guess, you know, all we can do as citizens is to talk to our MPs and say, you know, what are you thinking when you do this? You know, and start getting ourselves educated and say, have you thought about this case from coming out of the Supreme Court, so you know that all this stuff that you're proposing with this lawful access crap is going to be unconstitutional. Why waste everybody's time? Like,
Exactly.
point it out to him. Point it out to him or her, whoever it is. In passing, I can't help but have a little tiny little stab. I have an issue because my particular MP is Rob Anders, and so it's not an easy thing to talk to him, and he perceives me as a person who supports child pornographers because of where I work, and so it's very difficult for me to get anywhere with him, but I do try, and I also try the opposition as much as possible, and the way I do it is to give them the data and the education about this stuff, because it's complicated, and stuff say, have you asked this question? Have you asked that question? This is what I try to do. That's all I can think of to do. Not very satisfactory.
You should try waking Rob Anders up first when you try to talk to him.
I'd rather not. Sorry.
You'll listen better.
Okay, another question? We'll take you in the corner.
Yeah, I'll direct this to Ryan, first of all. What do you make of this phenomenon of the politicization of the charter over these last few days? We've got Mr. Harper with this very muted.
Sorry, what was that?
Sorry, we've got Mr. Harper with this very muted response.
Yes.
We have the Liberals trying to trademark the charter as a Liberal victory, and we've got the NDP who have clanned, presumably, because they don't want to annoy anybody in Quebec.
Yeah.
So, I find this very, very odd. I'm very interested to know your reaction.
Yes, sir. I find it very interesting too. For I think a lot of the reasons that you just kind of alluded to, and I have to take a line from my colleague Linda. I mean, I'm not a political scientist or an expert in local politics, but. I don't know. Maybe. I mean, I think it's fair to say that for the Liberals, obviously, this is arguably it is the crowning achievement for the Liberal government of Pierre Trudeau, and maybe with Stephen Harper, mutedly referring to the charter and saying, well, it's not really that important, or it's a document that has some controversy to it. I don't know. It almost seems like to me it's. Maybe this is going to sound facetious, but it's almost like. Everybody's after the hot girl in the room, and Stephen Harper saying, well, she's not really that important to me, but in fact she really is. I'm getting serious. I'm just speculating because I'm not a political scientist. It may very well be part of Stephen Harper's desire to appear soft on the charter for political gain in the province of Quebec. I mean, there still are, people in Quebec who would support sovereignty for Quebec, and whatever that means, because we've never really had anybody actually come up and spell out what that means. But maybe it's for some narrow electoral gain. But I mean, I've lived out here in Alberta long enough. I'm not from here originally. I'm from the Far East, as I call it, which is Nova Scotia. I know that for some people here, the East ends at the the Quebec border, but yeah, Saskatchewan. But I mean, I have noticed that since I haven't been here long enough to notice that there does seem to be an ingrained culture here of distrust of Central Canada and federal institutions, and distrust of the Charter, and distrust of lawyers, and distrust of judges, and anybody who's gone to university is an elitist. And I want to say that I don't think that's representative, obviously, of all Albertans, because I know some Albertans were very broad-minded and tolerant, and by the way, I mean, it's not like there isn't racism in Toronto, or even my home province of Nova Scotia. Of course there is, but I'm not sure. I guess that's how I have to answer your question. Is I really don't know. I mean, I can understand why the Liberals are quite honestly celebrating the Charter, but I mean, it is a charter for all Canadians. I don't think that John Chrétien was speaking in hyperbole when he said it is a document for all Canadians, because it is, and it has benefited, obviously, millions of Canadians. But as to why Mr. Harper would demean and disparage it, I don't know. And maybe that's not a satisfactory answer, but it's an honest answer. I don't know.
Can I say something? I think they should be ashamed. I think it's actually awful. And I don't care if they're MVP or whatever, trying to I think it's disgusting, because it's not a political document. This is a document about basic human dignity and rights. And if we don't stand for that in this country, then what do we stand for? And I think it's shameful. I think it's like embarrassing, actually, that we don't acknowledge the 30th anniversary of something that we are known worldwide for, and that people say they've come to Canada because they think we respect rights, because of the Charter. They're so enamored with it, and I'm saying, well, it's not all that great, but still. I think it's shameful. I don't know if it's political. I don't care. It shouldn't be political. It's shameful. Terrible.
That reminds me, when I was down at this conference in Buenos Aires in December of 2009, I was not only the only Canadian, I was the only North American, actually the only English-speaking person there, and there was a colleague, law professor from Chile, who, I mean, we had a great chat, and he was just a kid when Chile had a brutal military dictatorship under Pinochet, and he said that our charter was indeed one of the documents that the Chileans looked to after they finally did rid themselves of that military dictatorship, and they based the Constitution on our charter. And irony of ironies, there's Harper down in Chile now, negotiating for better for some trade with Chile. I think it's appalling that he would not recognize this important milestone in Canadian the evolution of Canadian democracy.
In the corner over there.
My name is Douglas Ray. I'd like to ask a bit of a supplemental to the previous question. When we talk about the politicization of the Charter, that is a concern of mine, but not from the political party's point of view. I don't really care about the present government, or the last government, or the future government. I do care about the judiciary, who must enforce the Charter. And we have the situation of the American Bill of Rights, now being interpreted by a Supreme Court of the United States that has become highly politicized, and its credibility has suffered. In recent years in Canada, in my view, we've seen the Supreme Court of Canada pull its punches in places where it shouldn't. We've seen the Supreme Court of Canada make rulings without remedies. The trend, or the importance, or even just the possibilities are worrisome to me. So my question of each of you is, what can be done to strengthen the judiciary in the medium and long term in terms of how it deals with the Canadian Charter of Rights and Freedoms? That would be fine.
Yeah, and then we'll go back to us old folks.
Exactly what. Did you hear that okay?
No, the gentleman is too far away from the microphone. Could you repeat the question for me?
Do you want to come over?
I can summarize.
Okay, you summarize.
Do I need to- Can you hear me okay, Zach?
I can hear you now.
Yeah, okay. So just in summary, please jump in if I'm not summarizing accurately, but the gentleman referred to what he sees as the politicization of the Charter, more particularly the judiciary, and he alluded to the United States Supreme Court, which has become increasingly politicized over these past few years, and he was wondering what can we do, what should be done to ensure that courts in Canada, particularly at the Supreme Court level, don't fall prey to such politicization. And he alluded to recent decisions of the court over the past few years where they would make decisions without providing remedies. So how do we ensure that our courts continue to do their job, which is to interpret the law, and when faced with a law which is unconstitutional, they'll strike it down. How do we ensure that they continue to do their job without becoming politicized? Is that
It's a great question. Thank you very much for asking that. I think that first and foremost, there's one thing that we need to recognize is, I'm glad you brought up the American case, but thankfully things are not as bad in Canada right now as they are in the United States.
Yeah.
The Supreme Court in the United States has turned into a total bloodbath between Democrats and Republicans in trying to stuff their own people in there who are going to respect their own ideology. And as a result, you've got an unbelievably active Supreme Court in the United States that actively guts legislation, huge amounts of legislation, sometimes entire acts. For example, there's a huge debate going on in the Supreme Court, or at least in the federal court, with regards to the Obamacare package, right? You very rarely see in Canada this situation where such monumental pieces of legislation are automatically struck down. And even in Canada right now, as we've seen, of course we know that there's a remedial clause, the notwithstanding clause, Section 33 of the Charter of Rights and Freedoms, but that's never actually been invoked at the federal level. What we have seen under Harper, however, are a few trends. Number one, when federal judges and even the Supreme Court has come in to say that certain legislation is inconsistent with previous legislation, it doesn't mean that it's inconsistent with the Constitution, that it's inconsistent with previous legislation that is meant to bind governments. Take, for example, the wheat board. And I am, as a Central Canadian, not as well versed in the debate of the wheat board as I should be. But what I do know is that we've had federal judges and Supreme Court judges who have said unequivocally that previous legislation binds the federal government to hold a plebiscite on whether or not to end the monopoly of the wheat board. The federal government under Stephen Harper has ignored that and has decided to ram the legislation through both houses of Parliament immediately. I think that that's a major issue. Remember, we've got a government now that, despite the fact that it turned away from the Chinese for 6 years, it is very similar in the sense that they believe in rule by law, not rule of law. So not that previous legislation should be tying the hands of government and by definition limiting the actions of government and hence increasing individual liberty overall, but rather that any government has the right to just totally wipe the board clean immediately and put in its own statutes with a mandate that it has won. Take, for example, as well, the Omnibus Crime Bill, which could have sections of it struck down for cruel or unusual punishment as discussed in the Charter of Rights and Freedoms. Major issue on that front, but they've been ramming that through as well without any debate on the cost or on the repercussions or anything like that. They're open closure all the time. What I do see as issues with the Supreme Court, more so than the appointment of anti-progressive judges to the Supreme Court, which is a possibility. Thankfully, I don't think we've seen that much of that so far in Canada. What I do see as a major issue is a threat to official bilingualism. And the fact that Stephen Harper has already appointed 2 Supreme Court judges that don't speak French, has appointed an Auditor General who does not speak French. This is a major problem. And regardless of your ability to interpret the law, regardless of your math capabilities, if you're going to be able to reach out to all Canadians, if you're going to be able to be competent in that role, you need to be fully fluent in both official languages. I see that as a particular problem. With regards to the role that the Supreme Court has been taking, the point that you raised is that theoretically they've been making decisions that are anti-progressive. That we've not been seeing as much. But what we have been seeing is a difference in how the Supreme Court reacts, which you did bring up as well, how the Supreme Court reacts to legislation. What they used to do in the past is to say that certain legislation is inconsistent with the Charter or with the Constitution, and hence go back to the drawing board and make it consistent. What they've been doing more so, and what's more controversial in recent years, is automatically ending the legislation themselves. Basically, the judiciary acting as legislators, saying the legislation should read X. That's a major issue. It's a big question of how I'm glad you raised it, how we're going to be able to put that to bed. We're now engaging, thankfully, in parliamentary hearings on appointing Supreme Court justices. This is a very new thing. Did not exist in the past. You just had the Prime Minister pick Supreme Court justices now. However, our problem is that the majority of the people on the board that is appointed to oversee these hearings of the appointment of Supreme Court justices are just like committees populated by the majority of Parliament. So, and in this case, exclusively by Conservatives. So I'm particularly concerned on that over the long run. I think that it points to democratic deficiency in many elements of our government. Take the ability of the Prime Minister to appoint senators without any restrictions whatsoever. That's another problem as well. And what it's going to take, and I'll go back to my remarks that I made during my talk, what it's going to take is someone who's capable of uniting the Canadian people on political lines on a clear mandate to bring about change. And I know the argument that no one wants to dismantle the system that gave them power. But here's an example. You take power on a mandate to effect democratic reform and system reform, and then you pose those in a referendum to Canadians, not during your term, because if it's during your term, then as we saw with Beach Lake, and not with Beach Lake, but with Charlottetown, is that the referendum that is going to be taking place on these very important constitutional issues have very little to do with the constitutional issues themselves and a lot more to do with the popularity of the Prime Minister in question. And Charlottetown was very popular at first, and it's too bad it didn't pass, but seeing as Brian Mulroney was unbelievably unpopular for the GST at the time, and a wide variety of other issues, it regrettably ended up failing. So what could be done is to bring a referendum up, as we've seen in BC and in Ontario, to coincide with the ensuing federal election on finding ways and letting the Canadian people weigh in on how to make the system more democratic. But again, it takes the will, and it's going to take inter-party cooperation to get it done. And such a climate, changing such a climate will require a long term to be effective beyond one single administration changing the system. But we need someone to do it first and foremost, to have the will to do so, and hopefully we'll see that in the years ahead.
Just a quick comment. I think that actually the Supreme Court of Canada has been overly reactive and sensitive to criticisms that it's activist. And it strikes at the very heart of judicial independence, which is another really important basic constitutional principle in Canada. And there have been a couple of legal scholars who've actually written about that. One of them is Patricia Hughes. She wrote an article about how, where you said they kind of pull their punches. It's a lot of it's because the rhetoric, and it's a very common rhetoric in Alberta here, let's be honest, that this charter allows legislation, and allows the courts to have a different role, and it's judicial activism and so on. And I think they're very sensitive to that, probably overly sensitive, right? They shouldn't be reacting this way. So I have, in my particular little corner of the world, I've been writing blogs and so on, where I say right out front, I feel that in this particular case, that the Supreme Court was unfairly accused of judicial activism, to support them when they actually do the job that they've been empowered by Parliament to do by the passing of the Charter, right? That is what they are asked to do, is interpret the law. I also want to point out that what I see as the most common remedy is not necessarily just striking down the legislation, which is what they're commonly doing, but they're usually giving time. And the time is supposed to be to get in this dialogue that we're supposed to be having. And the idea being, we're saying there's unconstitutional, but we're not going to put this in effect for 12 months. Parliament, fix it. And what used to happen is that it would go back and forth, and eventually we'd get a ruling that the new drafted criminal law, or whatever it is constitutional. And that's the ideal way to do it. But if they're so fearful of being, or so sensitive, and judges need to not be sensitive to that. They should just do their job and do it based on precedent and principle. And sometimes judges are unpopular. They're not in a popularity contest. And they need to leave their politics at the door. Seriously, what other people think, too bad. It's a rough job, and they need to be encouraged when they actually make decisions that are the right decisions. The common response is, oh, it's activism, and it's meant in a negative way. They're trying to rewrite the law, and that's not fair, because I think, if anything, they have recoiled and not stepped up to the plate when they should have and knew they should have. And the most current example of that I can give you is a case where they actually relied on Section 1 to say that we don't need equal pay in Newfoundland because it's going to cost too much money to do that, and we're believing them, and we're saying we're not going to make you pay any money out in Newfoundland. And it got back to Newfoundland, and it was so unpopular that the politicians in Newfoundland made the payments. But it was the court should have done their job in that case, right? So I agree with you. They are too timid sometimes, and we need to support them because they're too sensitive to criticisms, and they shouldn't be.
Yeah, I'll just add to that by saying that, yes, I agree that judges need to do their job without paying any attention to this social noise, as I call it. There's no other word for it. Social noise of new media, blogospheres, social media. I know they're supposed to do their job in a vacuum, and they don't, and but they should do what's right, step up and do the right thing. The charter exists to protect people on the margins, and I mean that does include people like Omar Cater. Would I want Omar Cater as my friend? No, but you know what? He's Canadian. He's been held in Guantanamo, and the Federal Court of Appeal has ruled that his charter rights were violated when he was tortured down there, and the government should bring him home. The government did not step up and do the right thing, and Omar Cater is still down in Guantanamo Bay. The charter exists to protect people on the margins. Well, no, it's there to protect all of us, but all of us includes people on the margins. Not only the Omar Caters of the world, but it includes as well, a young woman, a University of Calgary student who is, quite frankly, a Nazi. And I mean, a couple of years ago, there were photos of her, and there was a little handbill that went up all over campus. This woman is a Nazi, and if you see her, you should attack her. Well, you know what? I don't want to be this woman's friend. I don't want to date this woman. I'm not going to go drinking with this woman. But I don't want her to be attacked. And you know what? As heinous as her beliefs are, and I can't imagine how somebody in this day and age, knowing the history of the last century and knowing that not only did Nazism destroy the heart and soul of Europe, it destroyed the heart and soul of Germany, how somebody could espouse this viewpoint today is beyond me. But you know what? She's entitled to her heinous viewpoint. She's also entitled to be able to walk the streets without being attacked. To get back to your question, your original question of what do we do to ensure that the judges aren't politicized, I think as popular as this might seem at first blush, electing our judges is a bad idea. Because then you get judges who are pandering to the worst among us. And you know what? You've heard tell this phrase, we should have the tyranny of the majority. In another day and age in the United States, there are people who believe that human beings should be held as property. So if you had to have elected judges back then, you'd be electing judges who would think that black people deserve to be kept in chains and held as property. I think it's a bad idea. I think what we do in order to ensure that the politicization doesn't take place in our judiciary is we continue doing what works in this country. And to me, that's conservatism kind of, isn't it? If something works, you conserve it. And what works in this country is judges are appointed following this process. You've got I'll just stick with the federal level because the provinces have their own judicial appointment process for provincial judges. But the federal level, federal judges, and that includes the Supreme Court, are appointed only after, so first of all, they have to apply for the job, and then their applications are vetted by a committee that includes members of the Bar Council, the Judicial Council, so the judicial peers, it includes citizens who are members of this committee, and indeed it includes the Department of Justice itself. So the applications are vetted, rigorous interviews are undertaken, and then a recommendation is sent to the Minister of Justice, who has the final say in appointing somebody. That's how you ensure that our judiciary is not politicized. You get as many people involved in the process as possible.
I saw one more question back there. So.
Thank you. My question, I have three questions. They are all interrelated, so not really a problem. The first one is more of a summary of some of the things we've been talking about, and I would really love to get the thoughts of the panelists. 30 years, I mean, the period of birthday celebration is a good time to reflect. A 30-year-old person will look back and say, how far have I come? What have I done so far? So the best way to know the intended contributions of this charter would be to go back to the history of the charter. And I remember one of the main reasons of this charter was to instill a human rights culture in Canada and within all institutions in Canada. So my question is, will all the panelists say, or can you really say from your experience on the field, that 30 years after this charter has been adopted, is there really a human rights culture in Canada? Can you really say that this charter has led or has achieved on its promise? So I would really love the panelists to, because I know Brian spoke about some of his experience on the field and some of the unresolved issues that still arise about Quebec, the issues about trying to break away. Are these issues still there? Have they been, has the charter helped to resolve some of these issues in any way and in general? That's question one. Question two is about this issue of politicization, which we've been talking about. I know for sure that no sitting Prime Minister of the UK can say what Stephen Harper said. Same for a President of the United States. So it brings us to ask that, how come an important document like this can be so politicized? And it makes me to wonder, does it not come back to the issue of constitutional autonomy versus patriotism? Patriotism talked about bringing home a Canadian charter, while autonomy speaks about a charter should be homegrown, right? So an homegrown document would have passed through Liberal, Conservative, Green Party, or whatever. So does it not really go back to the fact that the Canadian Constitution and this charter is not truly homegrown, since it is a document that was brought home, of course, modeled after the UK? So that is the second question. Could we not really think, or can it not be said that this politicization is truly a call for us to look back and say, do we really need a truly homegrown constitution, an autochthonous constitution, an autochthonous charter? That's question number two. Then number three is that I know the approach of the Supreme Court of Canada has been to say the Canadian Constitution and this charter is a living tree that should be interpreted to fit in with new realities that were not existing when this document came into being. So my question to the panel is, how easy has this been, trying to use this charter as a living tree in the light of new issues that have come up, since 1982? Issues like terrorism were not popular back then. The rights of lesbian, gays, were not truly popular then. climate change, environmental problems were not popular then. So on the field, will you say from your experience on the field that it's been easy to really adopt or use this document as a living tree? And if not, what are your frustrations? What are your experiences? Or what are the frustrations? You know, because it's one thing to say that it's a living tree, it's another thing on the ground. So those are my 3 questions. Thank you.
Thanks.
Okay.
I did not, unfortunately.
Okay, so just,
You can repeat the question.
okay.
I'll summarize, and please jump in for clarification or correction if I haven't summarized your questions. So the gentleman had 3 questions, Zachary. First of all, do we think that there is a human rights culture in this country, which has come about with the advent of the Charter? Secondly, regarding the politicization of the Charter, the gentleman referred to what he thought was the cause of that, right? The cause of the politicization of the Charter, and his theory was that it's because this wasn't a truly made in Canada document, that the Charter and indeed the wider Constitution came from the UK. I know Lynn and I need to do some clarification there when we get into the constitutional history of this country. And the third question was the whole notion of the living tree doctrine, where this is a term, you probably heard it from some of your classes, Zach, but it's this notion that the Constitution is indeed, rather than something that's carved in stone and, we have to, well, we have to abide by it, I'm not going to stress that for a moment, but I mean, as the country evolves and as we have new challenges with each generation, that we have to have an ongoing debate and discussion about what's best for this country, and therefore the Constitution constantly needs to be interpreted or reinterpreted, if you will, to meet the exigencies of the day. Is that fairly?
Yeah.
Okay, perfect. Yeah.
Great, all great questions. Thank you for the summary there, Brad. Do we have a human rights culture? I think it's a phenomenal question because the interesting column actually by Jonathan Kay in the National Post came out just the other day, and his argument was that the Charter is so popular in Canada simply because of the fact that it enshrines the language of human rights, and that these things would actually not work effectively in society unless we had the values, the culture that actually bound us along those same human rights. And what he cited in his column is that going all the way back to Magna Carta, we have this same language that's present all the time in terms of ensuring the rights of individuals. However, his argument was that behind all these documents there were always politicizations and political, as you raised in your second question, political battles that are always going to be taking place. And so the intent behind them is sometimes tenuous. I happen to disagree with what he thought the intent behind the Canadian Charter of Rights and Privileges was. But going back to Magna Carta, we can see very clearly that human rights were not always ensured, and that Britain became a clear liberal democracy not because of Magna Carta, but actually without a constitution for a long period of time, simply because of the values that bind people as a society. And I think that that's what's going to continue to bind us in Canada for far longer. It's important to have the Charter of Rights to make sure that all rights are protected to the utmost degree. I remind you of what I was talking about before with regards to the Manitoba schools question and other, of course, more serious rights violations. But at the same time, it's not going to be as meaningful unless people are constantly keeping that alive, unless we teach those values to our children, to the next generations, and make sure that Canadian society values proceed and continue over the generations ahead. And I'm quite optimistic on that front. With regards to your second question, the cause of the politicization of the Charter of Rights and Freedoms, and that it comes from the United Kingdom, possibly. I mean, yes, the Queen was present at the signing ceremony back in 1982. Is that the reason why Quebecers have voted for opposition parties for 20 years? I don't think so. I think it had far much more to do with Brian Mulroney's mythology, tapping into what Ordinary and the Constitution had been saying, that Quebecers through the negotiations had been cheated, despite the fact that that was not the case. It was not the act of patriation itself that caused Quebecers to move away from the governing Liberal Party, but rather what happened afterwards, Brian Mulroney tapping into a national sentiment in the province of Quebec that eventually had Quebecers, at first had Quebecers in the governing fold for 2 straight elections, 84 and 88 under the Progressive Conservatives, but made for a very tenuous federation because bringing Quebec into the governing fold for him meant uniting it with alienated Westerners who basically both were united only in their hatred of Ottawa. That's what they really had in common at the time. Unlike Stephen Harper's government coalition right now, for example, between Ontario and the West, which I think is, for him, going to be far more solid since it's based more so on fiscal issues and the way that he's managed to campaign on economic issues in the past. So just to bring that up, it was, you know, in that sense, easier to break up, and that's exactly what we saw in 1993 when Quebec left the government fold and has not returned to it since. But it's without question a document that has provoked certain division, more so patriation than anything else, than the charter in itself, I think. But we just need to remind people of what actually took place in 1981. And despite the fact that there could be disagreement over the Charter of Rights and Freedoms, it should be noted that this disagreement is mostly limited to certain intellectual centers of discussion. It is not, in its essence, a profoundly divisive, essentially divisive document in Canada. So that's what I think that we should be reminding people of as well on that front. And with regards to your final question, is the living tree. Very important question, and it has to do exactly with the amending formula that was adopted. Because of the nature of our federation, the provinces obviously wanted to make sure that they had as much of a say as possible over possible changes to the Constitution, and in particular the Charter of Rights and Freedoms. What we got as a result is what is commonly known as the 750 rule, which is that normal amendments to the Constitution would require, unless they only affect the powers of one province, they would require the support of 7 different provincial legislatures, plus of course the 2 federal houses. And those 7 provinces need to represent at least 50% of the overall Canadian population. More contentious, larger issues like changing the composition of the Supreme Court or other issues like that would require unanimous consent among provinces. And yes, that makes it more difficult to amend than other than other constitutions in other countries. That's absolutely a good point. However, I think that we should note a few things. Number one, many people who think that the Charter is a good thing, and there are lots of people who are opposed to the Charter in intellectual circles on both the left and the right? The right thinks that it centralizes power in unelected, unaccountable judges and takes power away from provincial legislatures that are better equipped to deal with decisions that are closer to their constituents. The left will oppose it because they'll say that it's fundamentally an anti-progressive document, that it freezes our vision of rights and freedoms in 1982 and doesn't offer for changes. I disagree with that. But there are people who look at it in 2 different ways with those who support the Charter. One is those who are enthusiastic supporters of governing with the Charter. And then there are other people who can talk about governing around the Charter. Governing around the Charter in the sense that it's an important document. We're better off as a country for it. But at the same time, obviously, there are obstacles to be circumvented, especially as there are challenges that lie ahead. There are different interpretations, as you well know, that's in the Charter. But despite the fact that it's hard to amend, we should note that there are theoretical opportunities within the Charter to still advance both the rights of parliaments, of legislatures, and also to advance the rights of individuals. Of course, with regards to the rights of legislatures, we've got most prominently Section 33, the Notwithstanding Clause, which has not been invoked at the federal level ever, and has not been invoked at the provincial level since the 1980s, and I think that that's fundamentally a testament to the fact that judges over the past 30 years have been very moderate and responsible in the decisions that they've made overall. Secondly, what we're going to say here again, was Section 15, excuse me, Section 15, which was brought up before. There is a clear mandate in the Charter, and this was approved by the provinces who signed on to the Charter, 9 provinces, and the federal government. So we can't say that the provinces, have their rights being undermined by the charter. You know, the rights are being taken away and given to unelected, unaccountable judges and Ottawa. Beyond the fact that the charter actually did provide the provinces with extra rights, for example, jurisdiction over natural resources, and the composition of the Supreme Court, deciding what the composition of the Supreme Court could be, a wide variety of other rights that were provided to the provinces. The provinces signed on to the fact that judges, through the Charter of Rights and Freedoms in Section 15, have a clear injunction to engage in judicial activism. Through the phrase "in particular," and I'll read it. I like to keep the Charter of Rights and Freedoms right above my desk, actually, in my apartment. So Section 15, Part 1, Clause number 1 reads, every individual is equal before and under the law and has the right to equal protection and equal benefit of the law without discrimination, and in particular, without discrimination based on race, national or ethnic origin, color, religion, sex, age, or mental or physical disability. The important thing is the phrase "in particular." That is the trigger for judicial activism, in the sense that we're listing a bunch of rights that are ensured, right? But there are also other rights, right? That only says "in particular," those are the rights that are being particular here, but in particular, there are more rights out there, and we've seen extension of those rights, addition, on numerous occasions, with regards to Aboriginal rights, with regards to citizenship rights, and of course, most prominently with regards to gay rights, over the course of the past several decades. So it is a living tree in that sense, right? The Charter is constantly morphing itself. It's not an anti-progressive document, as the radical left would say. I think that it allows for progressiveness to continue over the decades ahead. And what's great is that if the judges get it wrong, right? If, for example, there's a possibility of having anti-progressive judges, we haven't had it en masse yet, but if it does happen, if the judges get it wrong, there's Section 33, right? There's an notwithstanding clause. And we've seen in the past, this didn't happen, because obviously it's controversial to invoke it, but we saw a decision back in the late 1990s by the Supreme Court regarding child pornography and its legitimacy, saying it's a fundamental right. There was a big question as to whether or not Jean Chrétien's government would have stepped in and said, notwithstanding the decision of the Supreme Court, child pornography is wrong and we should be limiting it as opposed to allowing more of it. So it allows for Parliament to come in and make the right decision as well. It's a perfect balance, and that's what democracy is. The Charter of Rights and Freedoms doesn't take power away from democracy and give it to judges. It deepens democracy. It adds for dialogue between the judicial, the executive, and the legislative, and I think that we're better off as a country for it.
Thanks, Matt. Okay, so we have about 5 minutes left, so if you guys want to quickly comment.
30 seconds. I think the first and the third question should be answered together. I do think that we have a long way to go in Canada with regard to, this has been my life's work for the last 20 years, is teaching people about human rights, and I'm always stunned